Schulman versus the Attorney General.
Thanks.
Mr. Busick?
Good morning, Your Honors. My name is Gary Busick, and along with my co-counsels Jennifer Levi and Mary Bonato, we represent the plaintiff in this action. This case presents a single straightforward question. What's the proper application of an exclusion in Amendment Article 48 of measures that relate to the reversal of a judicial decision? As I was shifting from briefing to preparing for oral argument, I had this sense that if you read our opening brief and its focus on plain meaning and read the defendant's brief in response, you might have a sense of ships passing in the night. And yet I think, in fact, there are a number of bases of common ground, actually, between us, and only one rather narrow space, but critical space, of disagreement. And I'd like to begin by reviewing what those...
The problem I have, and I know you recognize it, is what do we do about what was said in the Mazzone case? Now, if it's not dicta, isn't that pretty much the end of the ballgame?
Your Honor, as I've read Mazzone any number of times, I realize, one, that the court there was addressing a statute. It had a very unexceptional holding, actually. Mazzone really says that if an initiative law is proposed to amend an existing statute, it is not excluded simply because a court has opined on the meaning of that statute. And we completely agree with that position, and I think it applies across the board. It's actually one of the areas I think that we have common ground about, and that is that as long as the people are seeking to either change a law that's been construed or change a specific constitutional provision that's been construed by the court, that generally then we are not within the realm of reversing a judicial decision.
Could I ask you, that's what I picked up, I think, more clearly from your reply brief.
Yes, Your Honor.
But I am puzzled by what you, if I understand that correctly, what you seem to be conceding is that the petition process can be used in a way that would certainly have the effect of what you would consider reversing a judicial decision, but you're just trying to say, but they have to do it by changing either the specific statute or, in a constitutional case, the specific provision in the Constitution. And I have a hard time, with all of the very scholarly presentation both sides have given us about the debates and whatnot, seeing where is that distinction drawn in either Article 48 itself or, more importantly, in these debates. You seem to be conceding, yes, there is a way to, quote, reverse a judicial decision, but you've just got to do it this particular way.
I think, Your Honor, if I can come at it in one way, and maybe this won't be helpful and you'll let me know another way to come at this, because I think there's a number of ways you can think about this. But one way is that clearly in the minds of the convention, at least if you look beyond the voters and what they would see as the plain meaning of this language when it came to them, but if you look in the minds of the delegates at the convention, there was clearly Teddy Roosevelt's recall mechanism was in the air. This idea that the people could simply take a decision and say the direct opposite of it was something that I think everyone agreed you couldn't do. They didn't want to do. When they said, when Mr. Walker, who was kind of the chief proponent of the initiative and referendum, stands up and says, I am not in favor of the recall of judicial decisions, when you look across the board at the debates, you realize that he doesn't mean anything as specific exactly as Teddy Roosevelt. He means the concept. He means the idea that the people shouldn't be able to directly attack an SJC decision. They shouldn't be able to have a referendum on that decision.
What if the legislature passed a statute that says women can't vote in Massachusetts, and we declared it unconstitutional? Could they then have an initiative petition to, well, I guess not. If it's a statute, that would fall within Mazzone. Okay, don't worry about it.
Isn't that language designed to prevent the legislation directed at reversing a specific decision?
Well, that's
changing the judgment.
Isn't it changing a specific case? Isn't that
No,
really what it's
I don't
designed
think
for?
so.
But isn't that the
Justice Cowan.
distinction between reverse? The word reverse has a very specific technical meaning. And it's a word that we use to void or to vacate a decision in a specific case or controversy. We use the word overrule when we want to cut off the precedential effect of a case. But reverse means a particular case or controversy. And didn't the convention really mean to say that when a court decides, the highest court in the state decides a case or controversy, that decision cannot be reversed?
Well, Your Honor, I think that one thing is true, and it gets complicated in this language stuff, but I think as we pointed out on a reply brief, that overturn and reverse actually are synonymous. When you look at
overrule is not synonymous with reverse.
And the thing is, that, though, Your Honor, that the Amendment Article 48 goes to measures. It goes to laws or constitutional amendments. It presumes, in the defendant's parlance, a legislative act that might have, and everybody admits, that it could have a judicial effect. It could reverse a decision. There are circumstances.
It won't reverse it cannot reverse a decision. Once the litigation between this proposal, this initiative, cannot reverse Goodridge. It cannot change the judgment as to the parties in the Goodridge case.
You even concede that much, because you say it applies only in the future, prospectively.
Oh.
So you concede as much as what Justice Spino is just asking you.
You mean,
Seems
Your
to
Honor,
me.
if this was designed to reverse the
it may
judgment.
overrule Goodridge, but it won't reverse it.
Well, absolutely. That's true. And certainly a petition that would seek to reverse a judgment would be precluded. At the same time, that doesn't tell you the end of the story as to how far it goes, because, one, they don't use the word judgment, as this Court has said in Mazzone, and as, again, the parties completely agree, you do find some inspiration, some sense of what was going on from the debates about the Teddy Roosevelt proposal, and there...
But we use a different word when we want to cut off the precedential effect of a decision. We don't use the word reverse, we use the word overrule.
Your Honor, they were very clear, though, if you're going to look at the debates where the defendants go, they were very clear that the Roosevelt recall, which is where the defendants say you have to read the word reverse as recall, and as you said in Mazzone, that was never intended. The recall provision of Teddy Roosevelt or any of the others that have been proposed, the few in Colorado, the one here in 1914, were never designed to reverse a judgment. They were only designed to change the rule of law within the Court's decision, but it was very specific. When you look at Ransom, who was the chief expositor of the Roosevelt rule, they made it clear this is not a mechanism designed to reverse the actual judgment of a court.
If we accept your position, then what about the argument that if we've ruled on, say, operating under the influence cases, then there could not be a petition designed to change the law on that subject?
No, Your Honor, that's not our position, Justice Cowan. And again, I think there is agreement among the parties that if the legislature passes a statute, this Court construes the statute and says it means X and Y, and the people say, that isn't quite what we thought. We thought it meant X, Y, and Z, and they propose an initiative law to change the law to say X, Y, and Z. That's not seeking to reverse this Court's decision. It doesn't comment on this Court's decision. The Court may well have been right as to what the statute meant, and the people just needed to clarify the statute. Your decision in the incest case is a good example, when the Court said that it didn't reach a particular type of conduct involving a father and a child, and even the Court invites the legislature to close this loophole, but we can't make the statute reach that. And if the people had proposed an initiative to change that law rather than the legislature doing it, that would not be reversing the decision of this Court. We all agree on that.
Well, what about, in the, I can't remember whether it was 1980 or 81, this Court basically declared the death penalty statute inconsistent with the Constitution. What if we had declared that statute consistent with the Constitution? Would that preclude an initiative petition to change the Constitution to outlaw the death penalty statute?
Well, Your Honor, I think that this raises one issue, that what happens when you talk about a situation where the Court has not declared a law unconstitutional? I think we all agree that kind of the prime case, and I still submit that this case can be decided as applied to this particular petition that looks exactly like the type of question that the Teddy Roosevelt mechanism was talking about when you have a due process challenge about a police power issue where the people have some people have a disagreement with that decision, and what can the people do in response to that decision? There are many circumstances that could come up, but I would assume, Your Honor, if we're looking more broadly, and I think that we as plaintiffs opened up the discussion in our reply brief because of perhaps the court's concern of looking for a broader
standard.
standard.
Isn't the answer to Judge Cordy's question that the people clearly could amend the Constitution to say there'll be no death penalty in Massachusetts?
Your Honor, and I think that what our point is that, and again, the parties agree that the people can amend the Constitution, the provision that's construed, just as it seems crystal clear, and that Mazzone, I think, makes this point, that if the court construes a statute, then the people's power to write a new statute is untouched by this. It isn't a reversal. If the people want to change the Constitution, when the example, if I can try the example of the 1994 graduated income tax that the defendant raises, that this court said that a proposed statutory structure that had a broad range of personal income tax exemptions said, you know, when we're looking at the amendment, I think it's 64, and the question of whether this fits in with the uniformity requirement and not the reasonable exemptions requirement, this court said, no, it doesn't pass muster. The people proposed a constitutional amendment to change Amendment Article 64, to change 2 sentences in it, and then they proposed a law to have a graduated income tax that, if that were passed, on the assumption that the amendment changed. And that mirrors exactly what we see in the debates when people, like all of the proponents actually, when they talk about the question of how did they envision this process working. Walker says they may change the Constitution so as to permit the passage of that law. They would so change the Constitution so as to permit the law to be passed. They used the New York workers' compensation situation as a paradigm model of what they were talking about. In that case, the Court of Appeals declared a workers' compensation law unconstitutional. In that case, the legislature proposed an amendment to the Bill of Rights in New York Constitution that said, nothing in this Constitution shall prevent the legislature from enacting a law to protect and going on about the health and safety of workers. What Mr. Walker said is, that's exactly what we want to preserve here, only the people should have the ability to do that. They should have the ability to change the Declaration of Rights. And you remember, that's what they fought about ultimately. But as the defendants agree, it came down to that we have to be able to change the Declaration of Rights to allow the passage of a law that we want.
But again, you seem to be imposing on this process a distinction without a difference. It would suggest that the only thing these proponents did wrong was to fail to identify the precise, insert this language in the articles of the Constitution that had been interpreted in Goodrich. That seems to me a sort of a hyper-technical distinction.
Your Honor,
to say they can do it, but they have to put it in the right article.
Your Honor, I have to say, though, that I think this is the key. I agree, I understand your comment, but I think the point is that what you're trying to do here is balance 2 very strong competing narratives that came out of the debate. One of those narratives was, we're going to protect the judiciary. There were a huge number of amendment proposals to abolish judicial review, to change judicial review, to the election of judges, for the recall of judges, for the retirement of judges, for changing Article 9 so that amendments could be done by the legislature in a different fashion, for talk about recall, for talk about people's amendment processes, and they rejected them all, except that they changed Article 9 to make legislative amendments easier, and they consistently said, we're going to protect the courts, our judges, and their decisions. At the same time, they wanted to be sure that the people had the power to respond to decisions of the court. And the way to do that was to say, you can't attack a decision directly. You can't impose the law that you want. You have to go through a more reasoned process. You have to know that you're going to amend the Constitution's Declaration of Rights as construed by the court, if you want to have this law in the face of the Supreme Judicial Court telling you that it is not constitutional.
So again, you're saying the only mistake they made
Yes.
was failing to, they could do everything that they want, they just didn't say that they were amending the right article.
But it's important because of what the people are supposed to do when they are making this decision. They have to understand.
But I thought the idea was they have to do it by an amendment to the Constitution to make sure that it wasn't something that could be done, quickly, in the immediate aftermath of the uproar about Goodridge, that it was going to have to be a lengthy and considered process of literally amending the Constitution in some fashion.
Your Honor, that's important too. But one thing I think that I would have said if I had gotten to the one ground of disagreement between us, is that I think the defendants simply say is if it's an amendment to the Constitution, it's fine. That's end of story, because that's what the people can do. That cannot be. If you want this provision to mean something, because once you acknowledge, as I think you did in Mazzone and as all the parties here do, that it's not just an exclusion of a Teddy Roosevelt mechanism, but that it can actually be used, it has meaning in relation to the reversal of an individual decision, then the only way it means something if it excludes certain types of amendments. Because if you propose a law to reverse a constitutional ruling, it's futile. It's ineffective. I mean, the people could do it, but they have no more power than the legislature. That's what the exclusion section says. So it has to be done by an amendment. And so it means that a certain type of amendment that reverses a judicial decision must be excluded. And what we say is that's an amendment that attacks directly to impose in the law the exact opposite of what the court held. If the people want to do that, they have to go through a much more measured, deliberative process that asks the people, do you want to amend your Declaration of Rights, here Article 1 and 10, to actually allow the result that the marriage eligibility requirements could be changed? It cannot be imposed by a direct referendum vote on a decision of this court.
Thank you, Mr. Busick.
Thank you, Your Honor.
Mr. Sachs?
Good morning, Your Honors. Peter Sachs, Assistant Attorney General for the Attorney General and Secretary. Plaintiffs just acknowledged that the New York experience was the paradigm for what was adopted here, that the convention thought that the people should have the power to adopt an amendment, such as was done in New York, to respond to a court decision invalidating a statute. The amendment that was adopted in New York was not an amendment to New York's Due Process Clause or any other basis on which New York's workers' comp statute was struck down. It was a standalone amendment. It was not placed in the particular provision of the Constitution that the New York Court of Appeals had relied on in striking down the workers' compensation law there. So I think that the placement of this amendment as a standalone amendment rather than as an amendment to Articles 1 and 10 of the Declaration of Rights really has no relevance to whether this is the reversal of a judicial decision. This is the kind of thing that the drafters envisioned as a permissible response of the people to a constitutional decision.
The New York Amendment didn't say from henceforth workers' compensation schemes are constitutional. It simply changed or added some words to the Constitution, which then would have permitted the legislature to go forward.
It in essence, said nothing in this Constitution shall be construed to prevent the legislature from passing laws to protect lives, health, and safety of workers, including laws that set up a system of compensation and make it compulsory and allow compensation with or without a jury trial. It had some provisions that were very specific to workers' compensation. It didn't enact those itself.
Right.
Yes, it allowed the legislature to do so. But that, again, is a distinction without a difference, I think. The question
isn't the answer to this at least sort of contained in that passage in Mazzone, which says, the people can't act to reinstate a statute that we declared unconstitutional, but they can, in fact, amend the whole Constitution to declare a certain subject differently than we did.
Yes, we certainly agree with that portion of Mazzone, even though Mazzone itself did not involve a constitutional amendment, which no one can dispute. Mazzone found it necessary to look at the debates to interpret this phrase and found that reversal of judicial decisions originally meant recall of judicial decisions. No change in meaning was intended. And this was really meant to exclude the people from expressly declaring that the court had wrongly construed the Constitution and reinstating a statute that the court had invalidated.
Mr. Sachs, could you help me with this? There are statutory schemes. What about those cases, for example, it used to be under the common law, lots of people remained married, a husband and wife remained married, and the common law was that the legal domicile of the wife was wherever the husband happened to live, which this court said, that is not consistent with the Constitution and struck that down. Is it your position that through the initiative petition, because there are other ways to change the Constitution, through the initiative petition, the people of Massachusetts could say, it shall be the law that the legal domicile of a wife is wherever her husband happens to reside?
Unless that was within some other excluded matter, I think it would be permissible. It certainly is not within the reversal of a judicial decision exclusion, because it simply declares a new constitutional rule to be applied prospectively.
So this court rules that slavery is inconsistent with the Constitution, and the people of Massachusetts, through the initiative petition, say it is permissible to have slavery in Massachusetts. And you would say, well, those slaves that were freed in the period of time is fine, but slavery is permissible in Massachusetts. That's not a reversal of a decision.
Well, obviously the subject matter is very troubling, Your Honor, but I think the principle
but the
would be
position it's got nothing to do with how troublesome the subject matter is.
If it's a prospective constitutional rule that doesn't purport to declare that this court misconstrued the Constitution, then it would be permissible.
How do we...
It would not be within the reversal judicial decision exclusion, I should say.
Would you agree with me that, leaving aside whether they were looking at at the New York statute, which is what they were doing at the Constitutional Convention with respect to the workers' compensation statute, and leaving aside that the move towards initiative petitions was primarily grounded in attempts for social welfare reform, that would you agree with me that one of the things that animated the Constitutional Convention was the concern of representative government, namely the protection of minority rights, and the understanding that sometimes a court protects minority rights which can then be readily reversed by a majority, unfiltered majority in the initiative petition?
I would absolutely agree, and there was extensive debate over whether the entire Declaration of Rights ought to be placed off limits to the initiative process.
And they certainly didn't do that, but
yes.
They placed within that a clear judicial protection, correct?
A protection against the reversal of judicial decisions, but that was not intended to protect minority rights. That was intended to protect the independence of the judiciary, to prevent the people from invading the judicial field. One of the roles of an independent judiciary is to protect minority or property rights. So let me ask you a property question, right? This court rules that a statute that prohibits the sale of non-dairy creamers, actually was a regulation, and says that is in essence beyond the police power, it's irrational, and it's a taking of property. Somebody wants to market, it was actually Mr. Rich, wanted to market his coffee Rich, and we say that's inconsistent with the Constitution. There's no protection, there's no specific exclusion of property protection in the initiative petition, and the voters simply say, if you want to market, they don't like the decision of the court, and it doesn't go to Mr. Rich, but it's all the other non-dairy creamers, pass an initiative petition that simply says it's okay to regulate this business out of existence. That's acceptable. No, because there is a specific exclusion in Article 48 for takings of private property without compensation. I mean, there are two types of property issues that could come up.
But that's not taking property without compensation. It's simply regulating it out of existence.
A regulatory taking, I think, would count as a taking that didn't allow for compensation.
It wasn't
would count
a taking.
As,
it's a police power matter.
Well, that's always the question. Is it a legitimate exercise of the police power, or does it go too far and cross the line into a regulatory taking?
Go back.
And if it goes too far, and this is the argument that was made in the
Greyhound case.
The Greyhound case 2 days ago.
Go back to the slavery example, which you said they could do, troubling as it is. Are you saying that the people, after something is declared utterly discriminatory, and can just reinsert it in the Constitution? Something like slavery, to use that example?
Provided that it's not within one of the excluded matters. And
that
there was
includes, for
extensive
example,
debate over whether to exclude the entire Declaration of Rights, and the proponents of the constitutional initiative said no. That will completely that will frustrate one of the main purposes of the constitutional initiative. So we need to cut out of
That would
Sachs,
have
hold on one
profound
second.
implications on discrimination.
Mr. Sachs,
Well-
you would give the same answer, I take it. All property acquired during a marriage belonged to the husband. This court changes the common law and says no, property acquired during the marriage will belong jointly to the husband and the wife. It is the Attorney General's position that by an initiative petition, a majority of the then voters could say the Constitution shall state that all property acquired during the marriage will belong to the husband.
If that is not within an excluded matter, again, as troubling as the subject matter is, it would be a power that's reserved to the people. The people were very clear, the drafters were very clear that the people should be the masters of their own Constitution with certain specified exclusions in the Declaration of Rights.
So then we've got a Constitution.
And I should add here, it's perhaps stating the obvious, but we would always have federal constitutional principles
Well, yeah,
to deal with.
stating
So
the obvious.
whatever is done to the state constitution.
As you well know, because the jurisprudence is very clear, that state constitutions do not provide fewer protections than federal constitutions. In fact, they frequently provide more, and the whole scheme of federalism is not dependent on the protection of all of our constitutional rights under the federal
Absolutely.
Constitution.
Yes, but an example like the declaring that all property acquired during a marriage should belong to the husband, I guess there would be an obvious question whether that passes rational basis review under the Federal Equal Protection Clause.
But you don't, in looking at what, I think I'm correct in saying, in looking at what the limitations were that the drafters of the initiative petition aspects, Article 48 of the Constitution, were not relying on the federal Constitution.
Actually, in one place they were. In fact, one of the, I think it was Mr. Merriam, who proposed that after a proposal to exclude all of the Declaration of Rights was defeated on the ground that it would frustrate attempts to pass social welfare legislation. I believe it may have been Mr. Merriam, but someone in that passage there around page 1,000 of the debates said, well, due process is not expressly placed off limits by this more reduced version of the Exclusion Declaration of Rights, but we always have the federal due process clause anyway.
And that was not accepted.
No, that was accepted.
That was accepted.
The proposal to put certain parts of the Declaration of
No,
Rights,
I
not
understand that.
including
I understand
liberty
that
and
piece of it.
property and due process.
But there was
off
no inclusion of the, notwithstanding the federal due process rights.
Well, that's not explicitly in Article 48, but I think everyone understood that federal principles would continue to apply. I think the critical feature of the reversal of judicial decision exclusion is it meant to stop the people from acting in a judicial capacity, doing something that only a court could do, but not acting in a legislative capacity.
They're always
state the obvious. Some of the troublesome hypos that you've been presented. It seems to me they have nothing to do with reversal of judicial decisions. Well, there have been no judicial decision on the subject. That people could still, by initiative petition, put some very troublesome, what we would view as troublesome, amendments out there.
Well, if I get the drift of your question, the Albano case said that there was nothing wrong with inserting into the Constitution a rule that would basically say marriage is limited to one man and one woman in order to prevent this court from issuing a contrary ruling. Albano was about a petition that was proposed while Goodridge was making its way to this court. And this court said in Albano that doesn't interfere with the powers of the courts. So if it can be done beforehand to stop a court from ruling a particular way.
The difficulty that I have, as you can tell by my questions, is of course people can put very troublesome things into constitutions. Of course they can do that. And by going through the original, through the legislative process constitutional convention, people can put very troublesome things into constitutions. What concerns me is the entire structure and the reason why one has an independent judiciary, which is to protect certain groups of people. It is at the core of what makes the United States different from parliamentary supremacy, for example. And so
Absolutely.
to read and interpret what is happening, essentially it seems to me that what the Attorney General has substituted is a system of parliamentary supremacy, namely the will of the majority always trumps.
No, I would resist that, Your Honor. First of all, the drafters decided that particular key provisions of the Declaration of Rights should be placed off limits to the initiative, but that others would remain subject to the initiative. However, initiative petitions have to go through a very lengthy deliberative process. It's not like the recall of judicial decisions. If you had recall, such as was proposed in Massachusetts in 1914, then a question about whether Goodridge was correctly decided could have been on the November 2004 ballot. This proposal has to go through two successive legislatures, and the earliest it can be on the ballot is November 2008. And you have an intervening legislative election. You have time for people to decide how they really feel about same-sex marriage.
Nobody is questioning that. Nobody is questioning that the indirect form of initiative petition, which is the way it's commonly called, that Massachusetts did not follow California and other Western states that have
and that protects minority rights. The deliberative process protects minority rights.
But I take it part of the answer to the Chief's question is that if this could have been done before there was any judicial decision-making in the area, with similar
as in Albano, as this court said in Albano, it didn't interfere with powers of courts.
Why couldn't it be done afterwards?
Why can't it be done afterwards in the same one-step process as was done in Albano? The Albano petition didn't say the legislature is authorized to limit marriage to one man and one woman. It said, reduced to its essence, it said marriage is limited to one man and one woman.
To go back to the slavery example, and I know your time is almost up, but if they put slavery back into the Constitution, thereby reversing a decision that we may have issued, do you say nothing could be done about it? Could they come back to this court and say...
They could come back to this court with a federal constitutional claim.
Well, no, with a state constitutional claim saying, you just can't have such a violation of the Constitution put back into the Constitution.
Presumably that would implicate some of the articles in the Declaration of Rights that are off limits.
Such as?
It might. Well, depending on, it could implicate property.
Certainly implicates
it could
liberty.
implicate freedom of elections.
So
it could implicate freedom of speech, all of which is freedom of association.
If we permit this to be voted on and it passes, they can come back here for another ruling, perhaps. You conceding that?
On this particular petition?
Yes.
I'm not purporting to foreclose any other constitutional challenge that might be brought to this if it were adopted.
It strikes me
all the Attorney General has to do is say, is it within the exclusions of Article 48?
It seems
Not
to me
is it
the
constitutional.
death penalty process back in the early 1980s is very comparable, where this court held that the death penalty violated the cruel and unusual punishment provisions of our Constitution. There was not an initiative petition.
It was not an initiative petition.
I understand that, but there was a legislatively initiated petition.
Amendment.
Changed that particular
Right.
part of the Constitution, and then the new statute was enacted, came up, and we declared it unconstitutional for another reason.
And an issue about the death penalty could raise an issue under the powers of courts exclusion to Article 48. But again, focusing solely on reversal of judicial decision, this amendment does not put the people in the position of declaring the Goodridge decision wrong, which is what the drafters were concerned about. And
Thank you,
this
Mr.
petition is not
Sachs.
within the exclusion. Thank you.
Mr. Lowlands?
Thank you very much. May it please the Court, my name is Jordan Lawrence, representing the interveners in this case. The petition of the proposed amendment does not reverse the Goodridge decision. The parties retain the relief they obtained from this court in Goodridge, and in fact, non-parties who after Goodridge obtained marriage licenses would not lose them if this proposed amendment becomes part of the state constitution.
What do you do with the slavery example, which the Attorney General conceded the people could put on an initiative petition?
I think, Your Honor, that if it was done by initiative, that there would be other provisions of the state constitution that might draw into question whether it could be put forward. I would say, though, I think...
Such as what? Property?
Possibly.
If two people of the same sex are living together but don't have access to the substantial property protections that go to marriage, does that involve property?
Well, it possibly could,
But the
but
property one is not among the articles in the Declaration of Rights that have been declared off limits for initiative petitions. Freedom of speech has, for
Right.
example.
That
It's off
is
limits.
correct, Your Honor. And I do think, though, that the main issue here is that this Court has said to protect the people's ability to amend the Constitution and to set the organic law. The provisions that are already in the Constitution were set by the people ultimately or by the legislature. It would be troubling if the legislature passed an amendment reviving slavery. But that they theoretically
that was a
could do that.
constitutional decision of this Court in 1783. The constitutional decision was actually, it wasn't statutory. I don't even think they had statutes, or very few of them.
Well, I would also add to this, I mean, that's possible, and I don't know what the legislature would do if and I don't think we're any threat of that coming back. But the petitioners do concede that there is a way
I think
to...
the issue always is, what are the protections afforded despised minorities?
Well, that's what the people and the legislature set when they devised the Constitution. The Constitution did not come from somewhere else. It came from the people.
Absolutely.
And if the people placed those protections in the Constitution, then it would be they would probably sustain them under some ill-regarded constitutional amendment proposed by the legislature or by a renegade band of citizens using the initiative process. But the petitioners...
I would hesitate to call anybody who uses the initiative process a renegade band of citizens. Citizens...
Well, if it's a troubling subject matter, that's what I mean, that it was bringing up, that if the amendment process can be abused or used in a proper way by anyone. Just one final point, Your Honors, that the petitioners concede that there is a way that the amendment could have been done, but it was done improperly. What they suggested is an amendment that says the legislature, if it wants to, can define marriage as a man and a woman. That would be just as a direct reversal of Goodridge as the amendment that's proposed here. So I think that that is really a distinction without any difference, and that if that amendment is allowed, then therefore this proposal should be. And we'd ask this Court to affirm the decision of the Attorney General to let this go forward.
Thank you, Mr. Lawrence.